Solicitors. What is the strangest or oddest law that's won a case? Story 1. I had a client who was facing charges for trespassing on a property that he didn't own. It was a very straightforward case until my client told me about a strange series of events that led to the alleged trespassing. The property in question had a no trespassing sign at the front gate, which my client completely ignored because it was covered in overgrown vines, so he didn't even see it. Now, this is where it gets interesting. Apparently, the vines had been growing in such a way that the sign was virtually hidden from view, making it unclear whether there was an actual boundary or if the property owner was just marking the area for decoration. I thought it was a long shot, but when I started researching local ordinances and zoning laws, I found a strange and obscure law about inaccessible signage. According to this law, if a no trespassing sign is obscured to the point that it's impossible to see from a public vantage, it doesn't count as an enforceable warning. In court, the judge ruled in our favor, stating that the law clearly required the sign to be visible, and because of the overgrowth, it couldn't be considered a valid warning. My client walked free. It was a bizarre legal loophole, but it worked in his favor. A strange win, but a win nonetheless. Story 2. One of the oddest cases I've ever worked on involved a situation where a client had been sued by his neighbor for noise complaints related to his excessive lawn mowing. The neighbor claimed that the sound from the mower disturbed the peace and was unreasonable. At first, I thought it was going to be a simple case, but then I noticed something strange during the discovery phase. The complainant lived in an area zoned for agricultural use, which, by definition, meant noise from machinery was allowed as long as it was between certain hours. But that wasn't the only kicker. There was an even older zoning ordinance that said agricultural work, such as mowing the lawn or using power tools on the property, was exempt from general noise ordinances entirely, so long as it didn't go past 7 p.m. The lawnmower in question was a very loud industrial-grade model, but under this specific law, the neighbor had no legal ground to complain about it. The opposing lawyer argued that it was an unreasonable disturbance, but the judge sided with us, stating that the zoning law took precedence. The case was dismissed, and not only that, the neighbor was required to pay my client's legal fees. Honestly, I had no idea something like this even existed, but it turned out to be one of those rare cases where an old, almost forgotten statute becomes the game changer. Story 3. In a civil litigation case, I once represented a client who was accused of trespassing when he took a short walk through a public park that happened to be surrounded by privately owned buildings. The buildings had fences around their property, and the owners argued that my client crossed the boundary and unlawfully walked through their private land. The main challenge here was that there was no clear indication that the park was divided in any way. Upon closer inspection, I found a peculiar historical law on local property rights that stated that if a public park had once been open land, and the park hadn't been rezoned in modern times, it could still be considered public land, regardless of modern ownership. This law was decades old but still technically valid, and it had never been contested. It stated that any private structure built on land that had once been public, without a clear redesignation, could be overruled in favor of the public's right to pass through. The case became less about trespassing and more about proving the park's historical designation as a public property. The judge ruled that my client had a legal right to walk through the land because the park, even though surrounded by private property, was still legally part of the public domain. It was a weird technicality, but it won the case. Story 4. I once had a client who was charged with operating a business without a license. The client ran a small tech company that sold online workshops, but the local municipality required businesses like his to have specific licenses, even though they weren't conducting business from a physical location. The issue seemed clear-cut at first, but then I noticed a clause in the local business ordinance that had never been enforced before. It stated that businesses operated exclusively online and which do not engage in physical transactions were exempt from licensing if they did not have employees or customers visiting in person. The problem here was that this law had been overlooked for years, and no one had ever bothered to question it. The prosecution argued that my client was operating in a manner that fell under the traditional definitions of business, but we dug into the language of the ordinance. The judge sided with our interpretation, ruling that since my client's operations were entirely virtual and didn't involve any in-person transactions, he was exempt from the licensing requirement. It was a strange and obscure loophole, but the law was on our side. Story 5. One of the strangest cases I've had involved a zoning dispute between two neighboring properties. The case began when a local farmer was sued for using a piece of land near his house for growing a type of crop that wasn't allowed under agricultural zoning regulations. The catch? The crop he was growing was technically legal, but the county had a rule that forbade the planting of any new crops unless they were clearly intended for human consumption. The crop he grew was a rare type of flower used in the perfume industry, and it wasn't food-based. At first, it seemed like my client was in trouble, as the law seemed to explicitly forbid anything non-edible. However, I found a 1950s-era zoning clause that stated agricultural land could be used for commercial purposes tied to cultivation, as long as the crops were intended to be processed into a product that held economic value in local markets. Since the flowers were a key component in a well-known regional perfume brand, the judge ruled that the zoning restriction didn't apply in this case. It was a bizarre and outdated clause, but it ultimately saved my client's business. Story 6. I once represented a client in a rather bizarre case involving a parking dispute. The issue stemmed from a neighbor claiming that my client had been parking in front of his property, blocking his driveway. The twist came when we discovered that the parking spaces on the street had been marked by the city years ago, and the markings themselves were completely arbitrary, not following any official city regulations. In our research, we found an outdated ordinance that stated, "No vehicle shall park over a street marking or boundary unless the markings have been approved by the city council," which in this case had never been approved or formally documented. The law was an obscure one, almost completely forgotten by local authorities. Despite the fact that the markings had been on the ground for over 30 years, the city had failed to properly document them. In court, the opposing side argued that common sense should prevail and that my client should just move his car. But the judge agreed with our interpretation of the law, ruling that because the markings were unofficial and unapproved, they had no legal weight. My client didn't have to pay any fines, and the whole thing was dismissed. It was a strange, obscure law, but it worked in our favor, leaving the neighbor frustrated and my client with the victory. Story 7. A few years ago, I had a case involving an elderly couple being evicted from their home due to unpaid property taxes. They were on a fixed income, and due to a series of unfortunate circumstances, had fallen behind on their payments. The property had been in their family for generations, and their emotional attachment to it was immense. While we were going over the details of their situation, we stumbled upon an old, long-forgotten state law that dealt with property taxes for heirs. The law stated that if the property had been continuously owned by the same family for more than 50 years, and if the taxes had been consistently paid at least once in the last 10 years, the owner could apply for an exemption from eviction proceedings. The tricky part was proving it, because the law had never been challenged before. After diving into historical property records and doing extensive research, we found the necessary documentation to prove that the couple had met the law's requirements. The opposing attorneys were skeptical at first, but we made our case clear. Under this obscure law, the couple had the right to stay in their home, provided the payments had been made for several decades. The judge ruled in our favor, granting the couple a reprieve. It was a legal loophole buried deep in the state's history books, but it ultimately saved their home. The couple was overjoyed and grateful, and it reinforced the idea that sometimes even the strangest laws can be the key to winning a case. Story 8. One of the most unexpected victories I ever had was in a case where a client had been charged with violating a local noise ordinance. The charge stemmed from his music being too loud during a private party at his house. The neighbor had called the police, and the authorities issued a fine. My client, a musician, was confident that the noise had been reasonable, but the neighbor persisted in pressing charges. As we dug deeper into the case, I discovered that the local ordinance on noise control had a strange stipulation. It included an exception for musical performances in residential zones, as long as they occurred during a specified quiet time, which was between 10 p.m. and 6 a.m. The law had been written many years ago when a community center hosted concerts for the local residents, and this clause had never been updated or enforced. To make matters even more peculiar, the law defined musical performances in such a way that it included both private gatherings and organized concerts, regardless of the audience size. The exception essentially allowed for live performances, even if they were loud, as long as they didn't extend into the quiet hours. In court, I presented this historical loophole, and the judge ruled that the music, while loud, was not in violation of the ordinance. The case was dismissed and the fine was overturned. It was one of the oddest victories I've had, but it showcased how sometimes legal definitions can work in your favor in ways you never expect. Story 9. I once handled a case that seemed simple at first, but turned into an absolute legal nightmare. My client was an artist who had painted a mural on a large blank wall of an old building. The mural was vibrant, but a nearby business owner claimed it violated a city ordinance that banned unauthorized visual displays. The artist argued that the mural was not just an advertisement, but a piece of public art that contributed to the cultural landscape of the neighborhood. As we were researching the law, we discovered a peculiar exception in the city's zoning code. The ordinance explicitly allowed murals if they were in the. It goes to show that sometimes the weirdest, most obscure laws can end up being the most valuable when you're looking for a loophole. Service of community enrichment, which was a term that had never been clearly defined in the code. Upon further investigation, we found an obscure ruling from decades ago that stated public art that promoted local history or culture could qualify as a community enrichment project. The mural depicted elements of the neighborhood's history, such as landmarks and cultural symbols. It was clear that it fit within the parameters of the law, but the city's zoning board had overlooked this historical ruling. With this in hand, we presented our case, arguing that the mural was in fact a contribution to community culture, not just a random display. The judge, initially skeptical, ruled in our favor, citing the cultural importance of the mural and the outdated, but still relevant, exception to the rule. My client was allowed to keep the mural, and the business owner's claim was dismissed. It was one of the most unusual cases I've ever handled, but it showed me how important it is to look beyond the surface and explore the intricacies of old laws. Story 10. A case that I will never forget involved a seemingly trivial issue with a client who was being fined for feeding wild animals in a local park. The city had an ordinance that prohibited feeding wildlife, as it could create safety concerns and lead to the animals becoming too dependent on humans for food. However, my client was adamant that he wasn't doing anything harmful and that his actions were harmless, so we decided to contest the fine. As we reviewed the local statutes, we discovered something odd. There was an exception in the ordinance for spontaneous, non-commercial feeding of wildlife, as long as it did not result in a permanent change to the behavior of the animals. The key was in the word spontaneous. Apparently, if someone was feeding animals without the intent of making it a regular practice, and they did not cause any long-term dependency, the fine could be avoided. The twist in the case came when we found that my client had only fed the animals once, and it was a single, isolated event where he had shared a bag of peanuts with squirrels. He had not been feeding them regularly or creating any long-term reliance on human-provided food. When I presented this information in court, citing the law's specific wording about spontaneous feeding, the judge ruled that my client had not violated the ordinance. It was a surprisingly peculiar case, and in the end, my client walked away without a fine. The law, which had been in place for years, allowed for such odd exceptions, and the ruling made it clear that even small, unexpected legal details could have significant impacts on a case. Story 11. A few years ago, I represented a client who had been accused of trespassing on land that was technically part of a public park. The property had long been used by local farmers for grazing animals, but a zoning dispute left the park's boundaries unclear. My client had been walking through the park when the landowner charged him with trespassing, claiming the park extended far beyond the official boundaries. The case became complex because the exact boundary lines were poorly documented. While the property had once been used for agricultural purposes, the city had later redesignated it as a public park, but they had never updated the land deeds or any related documentation. This created a murky situation where there was no clear indication of where the park ended and where private land began. Through some deep legal research, I discovered an odd piece of local legislation dating back to the early 1900s. The law said that if a public park was designated in a city plan and became actively used by the community for 10 or more years, then the boundaries of the park, as defined by frequent usage, could be recognized as legally valid, even if no official boundary markers existed. This historical statute had been long forgotten by both the city and the local property owners, but it perfectly applied to this situation. I presented this historical loophole in court, and after some deliberation, the judge ruled that the park's boundaries were, in fact, broader than originally documented, allowing my client to walk freely across the land. The law's odd historical nature made it a bizarre but important win. Story 12. One of the most unexpected cases I worked on involved a client accused of violating a local law regarding unlicensed vending. The client, a street artist, had set up a small art stand on a public sidewalk to sell his paintings, but a city ordinance prohibited selling goods on public property without a vendor's license. The catch was that the law, written decades ago, had a specific exemption for public display art sales that allowed artists to sell their work without a license as long as they were only selling their own creations. The problem was that the definition of public display wasn't explicitly clear. Some people argued that it meant artists could only display their work in certain areas, while others believed it was a blanket exemption for all public spaces. I dug deeper into the historical context of the law and found that it had been written in the 1970s to support artists during a time when street art was gaining traction. In that era, it was common for artists to sell their work without government interference, provided they didn't disrupt traffic or public order. The case turned when I found an obscure clause within the exemption that stated individual artwork displayed and sold in an unstructured public manner could be exempted from fines. The law hadn't been updated in years, and as we reviewed the case, we realized my client's setup fit the exact description of the exemption. We went to court with this argument, and the judge ruled that the old law allowed for his art sale to be treated differently from regular street vendors. It was a strange, almost forgotten clause, but it saved my client from a fine and allowed him to continue his artistic ventures. It taught me that older laws, no matter how irrelevant they may seem, can often become the key to winning unexpected cases. Story 13. I was once involved in a case where my client, a small-town coffee shop owner, had been sued by a customer who claimed the shop violated health regulations by serving contaminated coffee. The customer alleged that the shop had not properly cleaned its brewing equipment, causing a health risk. While this seemed like a straightforward case at first, things took an odd turn when I investigated local health codes. As I pored through the regulations, I discovered a little-known law that stated any business involved in food or beverage services could be exempt from routine cleanliness inspections if the establishment had been in operation for over 50 years and had not had any prior issues with contamination. My client's coffee shop had been a beloved fixture in the town for more than 75 years, and the law was very specific about how it applied to businesses with this long-standing history. This strange exemption was included to honor the legacy of long-time local businesses that had been trusted by their communities for decades. I couldn't believe it, but it was a real law, and my client had no prior history of violations. I presented this historical clause in court, and to everyone's surprise, the judge ruled that the shop was not required to undergo additional inspections due to its legacy status. The customer's case was dismissed, and my client was able to continue serving coffee without the cloud of a legal dispute hanging over them. It was an odd, unexpected victory, but it perfectly demonstrated how an old law can help navigate situations that modern regulations might overlook. Story 14. I represented a client in a dispute with his HOA, where he had been penalized for improper landscaping on his property. The HOA cited that his front yard violated the association's rules by having an unusual design involving a mix of rocks, plants, and statues. My client, who had designed the landscape himself, argued that his yard was not only legal, but that it added aesthetic value to the community. After reviewing the HOA rules, I found an old provision that had not been enforced in years. It stated that homeowners were allowed to use non-standard landscaping as long as the design was not actively disruptive to the property value of neighbors. This provision had been included when the HOA was first formed, meant to give residents creative freedom in their landscaping, but it had been forgotten over time. The HOA tried to argue that the statues and rocks made the yard appear cluttered, but I countered that these elements were part of a well-considered artistic design. I brought in a local landscape architect to testify that the property was not only visually appealing, but added uniqueness to the neighborhood, in line with the old provision's spirit. The judge ruled in our favor, and the HOA's fine was overturned. The case became a prime example of how revisiting old and forgotten clauses can work in a client's favor, especially when those clauses were originally intended to encourage personal expression. Story 15. In one case, I represented a client who was being accused of violating a local ordinance that prohibited any unsupervised agricultural practices within city limits. The accusation came from a neighbor who saw my client planting a garden in her backyard, which was a seemingly harmless hobby. However, the neighbor argued that it violated the local rules about urban farming, which had been put in place to prevent the spread of certain pests. I found an obscure clause in the law that stated urban gardens with educational intent or those contributing to local food production networks are exempt from this ordinance. This provision had been enacted in the 1980s as part of a larger movement to promote sustainable farming, though it had never been invoked since then. My client had been using her garden to grow organic vegetables, which she donated to a local food bank. This fit perfectly with the clause about educational or community-focused gardens. I brought in evidence from the local food bank and community organizations to show how my client's garden contributed to local food production. The judge ruled in our favor, stating that my client's garden was exempt from the ordinance because of its clear educational and community value. It was a strange exception, buried deep in the city's regulations, but it turned out to be the key to winning the case and protecting my client's right to garden without interference. Story 16. I once worked on a case involving a client who had been fined for hosting a gathering in a public park, despite the event being a simple family reunion. The city had an ordinance that required any gathering with more than 25 people to obtain a special permit, but my client believed that the event, which was held in an open public space, was exempt. The challenge came when we reviewed the ordinance more closely and found a surprising exception. While the law was clear about large gatherings, there was an obscure clause stating that community-organized events which serve local charitable purposes or are non-commercial in nature were exempt from permit requirements. My client had organized the reunion as a way to raise awareness for a local cause, although it wasn't marketed as such. It turns out that a similar community event had been held in the same park a few years prior, also without a permit. And that was enough precedent to argue that my client's gathering could fit the same exception. The tricky part was proving that the event served a charitable purpose. To make our case, I presented evidence that the event included a silent auction for local charities and a donation drive. The judge agreed, ruling that the gathering was indeed a community-organized event and exempt from the permit requirement. It was an old, easily overlooked clause, but it saved my client from a hefty fine. Story 17. I once had a case where a client was charged with violating a local wildlife protection law after his dog chased a rabbit in a public park. The park was located in an area known for having endangered species, and the law prohibited any actions that could disturb these protected animals. My client, however, argued that his dog was just playing and that he had no intention of causing harm. While this might sound like a clear-cut case, there was an odd provision in the law that I found during my research. The law stated that it applied only if the person was willfully and intentionally disturbing a protected species. It was a strange legal distinction, and the law's language didn't account for unintended behavior, like a dog simply running after an animal. I decided to focus on the willful aspect of the law and argued that my client had not acted with the intention of disturbing wildlife. The key point was that he couldn't have known his dog would chase the rabbit, as it was an instinctive reaction rather than a deliberate action. To further support this, I presented expert testimony from a wildlife biologist who explained that the rabbit was not in any immediate danger, as the species was resilient and capable of escaping predators. In the end, the judge ruled that my client's actions were not in violation of the law, as there was no intent to harm the protected species. It was a strange case, but the key to winning lay in the specific wording of the ordinance.